Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about pig farmers and animal rights protesters. Cases that should have gone to the Supreme Court of Canada, but didn't. Miss Serrano was an animal rights protester who went to a pig farm and broke into the pig farm to film the conditions that the pigs were being kept in. She was ultimately charged with mischief for the actions that she committed, and her argument at trial was essentially that she couldn't be convicted of mischief because mischief required her to interfere with the lawful enjoyment or use of property. And her argument was that the manner in which the pigs at this farm were being treated was unlawful, in that they were subject to animal cruelty that would have violated provisions of the criminal code and provincial animal cruelty statutes. And so she said that mischief couldn't be committed as a result of her committing this activity because she wasn't interfering with the lawful use of property. She unfortunately was convicted at trial and lost her appeal at the British Columbia Court of Appeal and lost her application for leave to the Supreme Court of Canada. And this case does raise a very important issue, because mischief is meant to protect people who are engaged in lawful activities. It's not meant to protect people who are engaged in unlawful activities. And by extension, the determinations that the Court of Appeal made that mischief might apply in circumstances where somebody is arguably doing something unlawful could prevent people from taking the steps that they would need to take to interfere with unlawful activity where it poses a risk of harm in more obvious situations. If people fear that their actions taken to stop a crime from occurring or stop a crime that's in progress may lead to them being charged with mischief or charged with interference with the lawful use or enjoyment of somebody's property, they may be less inclined to interfere if they see criminal activity taking place and if they have the ability to stop it and there's no ability to call police officers or get police officers present before the criminal activity ends. The Supreme Court of Canada missed a very important opportunity to really clarify the law around use of property, and also to really consider the significance of animal rights in the context of animal rights activists who are doing work not to interfere with pig farming, but instead to protect the dignity and lives of the animals up until the point that they are going to be, unfortunately, slaughtered and used for food. And so the Supreme Court of Canada had the opportunity to really set a limit on where your obligation to comply with the law respecting other people's property ends when those people are doing something unlawful, and they didn't take this opportunity. This could lead to significant consequences in our society as a whole in the future, and it's unfortunate the Supreme Court of Canada didn't manage to correct what could come from this before it ultimately will happen. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Pull Creative for putting together these videos. Please like, subscribe, and share with your friends.